Love is patient, love is kind, love is highly monetized and aggressively protected. Every February, we drown in red hearts, apology roses, last-minute chocolates, diamond bracelets, limited edition wine labels, and playlists called Forever. It feels universal, ancient, untouchable. But behind the glitter sits a legal architecture, patents locking down mechanisms, trademarks claiming color, words, and even gestures. Copyright battles over love songs and literary retellings, domain disputes over panic-bought flowers, AI systems rewriting brand intent before you even click. This is not an episode about candlelight. It is about control, about who owns the interface of attraction, who can brand the word love, who can critique a classic romance, who profits from urgency, and how even your divorce might include your copyrights. Welcome to the 14 Love Battles. Because when love becomes commerce, Cupid needs counsel.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome back to Intangiblia. I am Leticia Caminero, and in this season, you are hearing my AI-cloned voice delivering my words.
And I am Artemisa, your fully AI co-host. I run on data, and I have zero patience for anyone who thinks Valentine's Day is just vibes.
Today's episode is titled The 14 Love Battles, 14 true love stories where romance met intellectual property, patents, trademarks, copyright, domain disputes, and now generative AI. Quick note, we use AI tools to support research and structure, but the legal analysis and commentary reflect my perspective, and this is educational, not legal advice.
Now let the IP romance begin.
Battle 1. We are in peak gifting territory, chocolate, shelf recognition, and one very famous shade of purple.
Not red, not pink, purple. Bold choice for romance, honestly.
Cadbury has used Pantone 2685C, a deep, unmistakable purple, on dairy milk packaging for decades. In the United Kingdom, that color became commercially iconic. Consumers did not need to read the label. They saw purple and thought Cadbury.
That is not branding. That is imprinting.
Cadbury sought trademark protection for that specific color, defined by the Pantone code for chocolate packaging. Not a logo, not stylized lettering, just the color.
Nestlé opposed. And this was not a polite objection. It became more than a decade of litigation. Because if one chocolate company owns purple, the rest of the aisle starts looking very beige.
Exactly. Nestlé argued that allowing one company to monopolize a color would unfairly restrict competition. Color is a limited resource in packaging. If purple is off limits, competitors lose commercial flexibility.
The courts had to wrestle with two key questions.
First, can a single color function as a trademark? Second, how precisely must it be defined? Early on, Cadbury had some success. But in 2013, the UK Supreme Court dealt a major blow. The issue was not whether purple could be distinctive. The issue was drafting.
Cadbury's application described the mark as Pantone 2685C, applied to the whole visible surface of the packaging, or being the predominant color applied to the whole visible surface.
That word, predominant, created ambiguity.
The legal system does not like romantic ambiguity. It likes boundaries.
The Supreme Court found that this wording lacked clarity and precision. A trademark must represent a single sign. If purple could appear in various dominant configurations, the scope of exclusivity was uncertain.
So Cadbury lost that version of the registration. So purple was emotionally exclusive, but legally messy.
Precisely. But the saga did not end there. In subsequent proceedings, including High Court decisions around 2022, Cadbury succeeded with more narrowly defined registrations. The key was precision. Pantone 2685C applied to the whole visible surface of the packaging, clearly and specifically described.
By tightening the scope, Cadbury preserved enforceable rights in defined contexts. So the lesson is, if you want to own a color, you must describe it like a chemist, not a poet.
The Cadbury Purple saga shows that seasonal gifting markets, including Valentine's, amplify the power of color. Consumers rely on visual shorthand, and if that shorthand becomes strongly associated with one brand, the law may protect it.
But only if you draft it properly.
Love is emotional. Trademark applications are not.
And in the chocolate aisle, precision tastes sweeter than poetry.
Battle 2, the flower keyword war, Interflora versus Marks and Spencer at the Court of Justice of the European Union. If Valentine's Day is the Olympics of flower sales, then search engines are the stadium. Marks and Spencer bought advertising keywords linked to Interflora's trademark so that when users searched for Interflora, they could see Marks and Spencer flower ads.
The modern tragedy is not Romeo and Juliet. It is, I typed Interflora and accidentally bought tulips from someone else.
The legal core is trademark functions. The court looked at whether the ad triggered by the keyword could harm the mark's ability to indicate origin, and for reputed marks, whether it created dilution or took unfair advantage of reputation. The test is not, did you use the word? It is, did your use impair what trademarks are for, namely letting consumers know whose goods they are buying and preventing free riding on a famous sign.
So it is not illegal to compete. It is illegal to compete in a way that makes people think they are still holding Interflora's hand while they are actually in Marks and Spencer's cart.
The outcome, practically, is that keyword advertising can be lawful if the ad is clear and does not confuse users about source, but it can cross into infringement when it obscures the commercial origin or exploits the competitor's reputation. This battle is perfect Valentine content because urgency is part of the consumer psychology. People do not shop slowly for apology roses. They panic, click, and hope.
Love in the time of pay-per-click, tragic, efficient, and extremely trackable.
And here is where the flower keyword war becomes prophetic. Before, the fight was about who could trigger an ad when someone typed a competitor's name. The battlefield was the keyword. Visibility was bought. Confusion happened in the sponsored link.
Interflora was about interception at the level of the search term. You typed a trademark. A rival appeared next to it. Courts asked whether that appearance impaired the origin function of the mark.
Now move that exact logic into the AI layer. The keyword is no longer the battleground. The answer is,
today when someone types Interflora Valentine delivery, they may not even see 10 blue links. They see a synthesized paragraph at the top of the page, a generative overview, a direct recommendation. That shift transforms the legal tension. It is no longer about buying a rival's keyword. It is about how an AI system interprets and responds to brand-specific intent. In the old war, Marks and Spencer bought the word. In the new war, the system rewrites the response.
Battle 3. Chegg versus Google enters the conversation. Chegg sued Google over AI overviews, alleging that generative summaries answer user queries directly using publisher content, reducing traffic and revenue, and leveraging Google's dominance in search. The complaint frames the issue as structural power. If publishers must allow their content to feed AI answers or risk invisibility, then control shifts from links to summaries.
So instead of intercepting a click, you absorb the destination.
Precisely. The flower keyword war asked whether a rival could appear next to a trademark search without confusing users. The AI era asks whether the platform itself can mediate, summarize, and redirect brand intent through generated answers. The legal principles, origin, transparency, unfair advantage, remain, but the mechanics evolve.
Love in the time of AI. You ask for Interflora. The system says, here are comparable options. And suddenly, the most important Valentine decision of your week is filtered through an algorithm.
The flower battle was about keyword bidding. The next battle is about keyword interpretation inside answers. And when urgency drives the purchase, especially on February 14th, clarity is not optional. It is legally essential.
Cupid once shot arrows, then came pay per click. Now we have predictive summaries. Romance evolves. So does competition.
Let's end this with the uncomfortable core of the debate. Some argue that lawsuits over AA summaries are really attempts to create a right to traffic. The idea that if a platform answers a query directly and fewer users click through, that loss itself is legally actionable.
Which feels fair emotionally, but legally. Traffic has never been property.
Copyright protects expression, not attention. Antitrust law may police real coercion or monopoly abuse, but it does not guarantee referral clicks. If an AI summary is transformative and does not reproduce excessive content, courts may see it as lawful platform speech.
So the fight is not about stolen words. It is about lost visibility.
And visibility has never been an entitlement. It has always been earned, optimized, and competed for.
Love might promise forever. Traffic never did.
Battle for the greeting card copyright clash of the 80s. Valentine cards look simple, but they are micro portfolios of copyrightable choices, original illustrations, layout composition, typography, and text that goes beyond generic phrases. The hard legal work is separating protectable expression from unprotectable ideas and standard romantic tropes, what the law often treats as scenes that naturally flow from the genre.
You cannot own hearts. You cannot own Be Mine. You cannot own a cheesy pun. And that last one is a public service.
The legal argument usually turns on substantial similarity of protected elements. Courts filter out the common building blocks, then ask whether what remains was copied in a meaningful way. This is why two cards can both feature a red heart and still be fine, but copying the same illustration style, the same visual arrangement, and a distinctive verse can cross the line. The outcome patterns are predictable. Strong cases win when the overlap sits in unique creative choices. Weak cases collapse when the similarities are just the universal language of romance.
Translation. You can borrow the mood, you cannot photocopy the charm, and you definitely cannot steal the joke because the joke is the whole product. Battle 5. The Greeting Card Association. A U.S. trade association representing greeting card publishers and designers, partnered with Temu, a global online marketplace platform known for hosting large volumes of third-party sellers. A match made in heaven. On one side, established card publishers. On the other hand, a massive digital marketplace.
Greeting card companies were facing widespread copying of their original designs by marketplace sellers. Instead of filing dozens of individual copyright notices, the association worked with Temu to implement AI-powered image recognition software. The tool can bulk identify infringing designs and automatically remove listings.
In other words, publishers create, sellers copy. The platform builds a filter.
The outcome reported by members was dramatic. Dozens of listings were removed in a single sweep, and in some cases, infringing designs were blocked before publication. This is not court enforcement, it is cooperative digital policing.
The parties here represent the new enforcement model, rights holders plus platform infrastructure. Battle 6. Love Pop is a U.S.-based greeting card company known for intricate three-dimensional pop-up cards. Its business model combines artistic design with patented mechanical engineering.
They do not just print hearts. They build paper architecture. Paper Love, LLC, is a competing card seller offering pop-up style greeting cards through online platforms. Love Pop alleged that Paper Love copied not only decorative elements, but the structural mechanics protected by Love Pop's utility patents.
So this is inventor versus competitor. Engineer versus imitator.
Love Pop sued in federal court in New York, alleging patent infringement for copying specific folding and slice form mechanisms, as well as copyright and trademark claims. The case was terminated in July 2025, most likely through a confidential settlement.
The parties represent two businesses operating in the same niche market, premium 3D greeting cards, where mechanical innovation is a core asset.
Lovepop also filed suit against Pop Life LLC, another company selling pop-up greeting cards. This case remains active. Battle 7. Hallmark is one of the largest greeting card and gift companies in the world. Its business includes designing, manufacturing, and distributing greeting cards through tightly controlled retail channels.
A legacy brand built on emotional moments, distribution discipline, and approximately 947 holiday movies where someone moves to a small town, opens a bakery, and finds love.
Dickens Incorporated was a wholesaler that acquired millions of genuine Hallmark cards that had been diverted from authorized supply chains and were intended for disposal. Dickens attempted to resell them.
So this was not counterfeit. It was unauthorized redistribution. No fake baked goods involved.
Hallmark argued that even genuine goods can infringe trademark rights when sold outside authorized quality control systems. The court agreed, reinforcing that trademark protection extends to maintaining brand control distribution.
The parties here represent a major brand owner and a secondary market wholesaler, and the dispute centered on control, not on creativity. Even in a Hallmark universe, the supply chain still needs a compliance department.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
Battle 8. This battle centers on one of the most iconic American love stories, Gone with the Wind. Scarlett O'Hara, Rhett Butler. Frankly, my dear. And the sweeping romance set against the Civil War South. The question was not whether the original was protected. It absolutely was. The question was whether someone else could retell that world from a radically different perspective while the copyright was still in force.
So this is not just romance. This is drama, Southern mythology, and one very complicated love story.
Houghton Mifflin published The Wind Done Gone, a novel that reimagined the events of Gone with the Wind from the perspective of an enslaved character, directly challenging the racial and ideological framework of the original. SunTrust, as trustee for the Margaret Mitchell estate, sued to stop publication, arguing copyright infringement.
The defense relied on fair use.
Specifically that the new work was transformative because it critiqued and commented on the original narrative rather than merely continuing it. The district court initially granted an injunction blocking distribution, but on appeal, the 11th Circuit vacated that injunction.
The 11th Circuit emphasized that parody and critical commentary can qualify as fair use even when recognizable characters and plot elements are borrowed. The court focused on transformation. Was the new work simply retelling the romance, or was it exposing and interrogating the mythology behind it? And the answer was it was confronting it, not extending it.
This was not a license to produce unauthorized sequels. Fair use still requires analysis of purpose, amount used, and market impact. But the ruling reinforced a powerful principle. Copyright protects original expression, yet it does not shield a cultural narrative from critique.
So the legal message is clear. You cannot simply cash in on Scarlett and Rhett's love story, but you can challenge the fantasy, reframe the history, and question the romance.
And sometimes in copyright law, the right to argue with a classic is just as important as the right to preserve it. Battle 9, the domain ambush. 1,800 flowers in the UDRP system. Valentine Commerce is a magnet for confusing domains because people type fast when emotionally compromised. In one WIPO UDRP decision, a domain built around the brand redirected users and even displayed branding elements, and the panel applied the three-part test, confusing similarity, no legitimate interests, and bad faith, registration and use, then ordered transfer.
So someone tried to catfish a florist. That is not romance. That is fishing with petals.
The legal depth here is important. UDRP is not about damages, it is about fast corrective action on clear abuse. Bad faith can be shown by evidence of intent to attract users for commercial gain through confusion, pay-per-click monetization, or impersonation. This makes UDRP a Valentine survival tool for brands because the harm window is short. A stolen click on February 14th is not just traffic, it is the whole relationship rescue mission.
Cupid uses arrows, cyber squatters use typos, And WIPO uses procedure, which is somehow more lethal.
Battle 10, gold, screws, and one of the most iconic pieces of jewelry in the world, the Cartier Love bracelet.
The bracelet that says commitment, but make it 18 karat.
Cartier is a French luxury jewelry house founded in 1847. Its Love bracelet, introduced in 1969, is one of its most recognizable products. The oval shape, the screw motif, the minimalist engraving of the word love. It is not just jewelry, it is branding engineered in gold.
And Cartier defends it like a fortress.
In recent years, especially between 2022 and 2025, Cartier has aggressively enforced its stylized Love trademark and related design rights. What makes this campaign interesting is that it partnered directly with Amazon to fight counterfeiters.
Romance meets platform liability.
In 2022, Cartier and Amazon filed joint lawsuits in the United States District Court for the Western District of Washington. One of the cases targeted a social media influencer account known as PHMN9Y3V, along with several businesses.
The allegation was clever and calculated.
The defendants allegedly used Instagram to post high-quality images of what appeared to be authentic Cartier Love bracelets, but instead of linking to a listing that mentioned Cartier, they redirected users to generic Amazon listings with titles like Classic Screw Titanium Steel Bracelet.
That is the hidden link tactic.
The listing looked neutral, no Cartier branding in the product title. That helped evade automated detection systems. But once the customer bought the generic bracelet, what they received allegedly bore counterfeit Cartier marks.
So the digital storefront looked innocent. The package was not.
The legal claims included trademark infringement, false designation of origin, unfair competition, and consumer protection violations. The theory was that this scheme intentionally bypassed platform safeguards and misled consumers into believing they were purchasing authentic Cartier goods.
And it worked long enough to trigger federal litigation.
In April 2024, Amazon and Cartier secured a default judgment against another seller, Whatsofen Incorporated, in a related counterfeiting matter. The court granted damages and a permanent injunction after the defendant failed to respond.
Which is a legal way of saying, if you ghost the lawsuit, the judgment still shows up.
Then in March 2025, Cartier won a major decision in Paris against a British jeweler, Gusan Limited. The issue was not counterfeit goods this time. It was use of the word love on bracelets.
Because love is a common word, but in jewelry, context matters.
The Paris Judicial Court found that Gusan used love not merely as a decorative message, but as a brand identifier. Combined with visual similarities and marketing claims like gold-plated or French-made, the court held that there was a likelihood of confusion with Cartier's registered love trademark.
The court drew a line. You can say love, you cannot brand like love.
Precisely, this case reinforces a key trademark principle. Even a common word can be protected if it has acquired distinctiveness and functions as an indicator of commercial origin for specific goods.
In other words, Cartier does not own love as a feeling. It owns love as a bracelet.
And globally, enforcement continues. Courts in other jurisdictions, including Dubai, have upheld protection of Cartier's 3D trademarks for its iconic designs. The protection is not just for the word. It extends to the form, the screws, the structure.
That is romance with registration certificates.
The broader lesson is about evolution. Counterfeiters are no longer just street vendors. They operate through influencers, algorithmic redirection, and marketplace loopholes.
They use social media as the storefront and e-commerce as the warehouse.
And luxury brands respond by combining trademark law, platform partnerships, and cross-border litigation.
If you see a love bracelet online for the price of a coffee, remember either it is not love or it is not Cartier.
Or both.
Love may be eternal, but enforcement is quarterly.
Battle 11, the love song fight, Skidmore versus Led Zeppelin, Stairway to Heaven. The claim was that Zeppelin copied protectable musical elements from Spirit's Taurus. The Ninth Circuit, sitting en banc, affirmed Zeppelin's win, emphasizing that copyright does not protect common musical building blocks and that plaintiffs must show copying of protectable selection and arrangement, not just familiar chord progressions.
You cannot own the feeling of yearning. You cannot own a descending pattern that half the planet has played. And you definitely cannot own the fact that guitarists love drama.
A key legal nuance was also about what evidence the jury could consider given the older copyright registration framework involved, and the court's approach narrowed the path for claims built on general similarities. For Valentine purposes, it is perfect. Love songs are an emotional industry, but copyright draws a line. It protects original expression, not genre grammar.
So you can write a love song, but you cannot trademark heartbreak in a minor, even if it is very persuasive heartbreak.
Battle 12, the luxury motif battle, Van Cleef and Arpels versus Louis Vuitton over a 4-petal clover-style motif and jewelry design identity. This one is Valentine adjacent because jewelry is the holiday's unofficial currency. The dispute turned on whether the motif and its execution were protectable and whether Vuitton's collection created infringement or unfair competition versus being legitimate use of common design vocabulary with enough differences. Recent reporting describes the appellate outcome favoring Louis Vuitton, with the French Supreme Court dismissing the appeal, essentially ending the fight.
Imagine trying to own a 4-leaf clover. The judge basically said, nature did it first.
The legal depth is the boundary between protectable originality and common motifs. Courts examine the specific composition, proportions, setting style, materials, and the overall visual impression, and they weigh industry norms, like offering multiple sizes or using popular stones. This battle is a warning to brands. You cannot monopolize the design language of romance. You can only protect what is truly distinctive and evidenced as yours.
Translation, you can own your signature, but you cannot own the alphabet of beauty.
Battle 13. Our next love battle takes place in the digital dating universe, where the swipe mechanic is as iconic as roses at Valentine's and as instinctive as double tap on a photo. This is Match Group versus Bumble, a real-world fight over who owns the interface that millions use to find a date.
So instead of roses and chocolates, these companies are swiping left and right on patents and trademarks. Let's break this down.
Match Group is the corporate parent behind Tinder, Match.com, OkCupid, and several other dating services. Its revenue and reputation come from matchmaking mechanics, user interactions, and the technology that enables connections. Bumble is a rival mobile dating app founded by Whitney Wolfe Herd, also a Tinder co-founder, that flipped traditional dating app norms by requiring women to make the first move.
The punchline here is not just modern romance, it's intellectual property. And Match Group's complaint was sweeping. Match alleged that Bumble's app infringed several of its IP rights. First, there was a utility patent covering a computerized matching process system and method, involving swipe gestures and mutual opt-in logic. They also claimed a design patent covering the visual card stack interface where users swipe left or right. And they argued that Bumble's use of terms like swipe, swipe left, and swipe right infringed Match's trademark rights. It wasn't just, you copied my feature. It was, you copied my feature, my design, and even the language people use to describe it.
Match also alleged that former Tinder employees who helped found Bumble misappropriated trade secrets, bringing insider knowledge and confidential development info with them into a competitor.
Bumble did not take this lying down. They fired back publicly and in filings, rejecting the claims and characterizing them as baseless intimidation tactics. Their bold response was featured in press and even published as an open letter, saying in effect, we swiped left on your lawsuit and your negotiation strategy. In dating app terms, that's basically ghosting a legal claim.
Legally, the dispute raised some classic IP tensions. Are software interface mechanics patentable innovations? Or are they abstract ideas that should remain free for anyone to use? Can a gesture like a swipe be trademarked, or is it simply functional language that describes how the technology works?
In software patents, there's always a big question. Is this a true invention or just an obvious digital metaphor for like or reject?
After about 2 years of litigation, Match Group versus Bumble did not reach a blockbuster verdict. Instead, it was resolved through an out-of-court settlement in 2020, and the lawsuit was dismissed, with terms kept confidential.
The public never got a clear judgment on whether swiping is patentable. But the case itself became a kind of precedent battleground, signaling how far big tech companies might go to protect user interface ideas and branding.
In the broader dating app industry, the dispute underscored the challenge of applying traditional intellectual property doctrines, patents, trademarks, trade secrets, to rapidly evolving software platforms where competitive differentiation can be just a few design decisions and user experience choices away.
Swipe right for romance, swipe left on ambiguity, but in the world of IP, you may still need a lawyer before you even design a second screen. Battle 14.
This last case comes from New Zealand and has become a major point of reference for creators and anyone with intellectual property tied up in personal relationships.
Because nothing says romance like marital assets and asset division rules.
The parties were Sirpa Elise Alalakola, a professional artist whose paintings were the family's main income source, and her ex-husband, Paul Palmer, after a 20-year marriage. Miss Alalakola painted dozens of works during their relationship, and at separation, the couple agreed that the physical paintings were relationship property under New Zealand's Property Relationships Act 1976.
So far, that sounds normal. Marital property gets split.
The dispute was over something more abstract and legally significant: the copyright in those artworks. Palmer argued that the copyrights created during the relationship should also be treated as relationship property and form part of the property pool to be divided.
In other words, he wanted a share not just of the canvases, but of the rights to reproduce and profit from them.
The case went up through the family court and intermediate courts with differing views, but the New Zealand Supreme Court clarified the law in 2025. It held that copyright in works created during the marriage is indeed property under the Property Relationships Act and qualifies as relationship property because it arises as a right with economic value when the work was created during the relationship.
So, copyright was official property for PRA purposes, just like a house or a car.
Importantly, the court did not take the copyright away from the artist herself. Instead, it confirmed that while Ms. Alalakola retained legal ownership of the copyright, the value of that copyright must be taken into account and shared as part of the property division. Palmer was therefore entitled to an appropriate financial adjustment from other assets to reflect his equitable share of the value of the copyrights.
Meaning she keeps the rights, but he gets compensated as if he shared in their value.
The Supreme Court rejected the idea that copyright should be separate simply because it stems from the artist's personal skill or creativity. It found that if a right has economic value and is acquired during the course of the relationship, then it falls within the scope of relationship property.
So yes, teamwork in a relationship can turn artistic rights into shared property, even if only one partner painted.
This ruling has practical implications for artists, writers, musicians, and other creators in relationships. Copyright in works created during a union can form part of the property subject to division on separation.
Long after the brush dries and the last gallery show closes, the law still counts that creative contribution as joint economic property.
5 takeaways.
First, distinctiveness beats emotion. You cannot own love as a concept, but you can protect a precise shade of purple, a specific bracelet structure, a defined interface, or a clearly registered mark. The law rewards clarity, not sentiment.
Second, visibility is power. From keyword advertising to AI summaries to domain names, modern battles are not only about products. They are about who controls what the consumer sees first, especially when urgency overrides analysis.
Third, copyright protects expression, not genre. You cannot monopolize hearts, heartbreak, or chord progressions, but you can protect your original arrangement, your visual composition, your narrative transformation.
Fourth, intellectual property follows value. It survives resale, secondary markets, platform distribution, and even marriage. If a right has economic value and is created during a relationship, courts may treat it as property.
Fifth, enforcement has evolved. Counterfeiters use influencers and hidden links. Brands partner with platforms. AI now mediates answers, not just access. The battlefield has moved from shelves to screens to summaries.
Love evolves, so does litigation. 14 reminders that Valentine's Day is not just about roses and feelings. It is about registrations, oppositions, injunctions, settlements, and sometimes Supreme Court clarification.
If you enjoyed this episode, share it with someone who thinks February is only about romance. Remind them it is also about rights.
Protect your ideas, protect your brand, protect your domain name, and if you are about to buy a love bracelet for the price of lunch, pause.
Happy Valentine's.
May your trademarks be distinctive, your contracts be clear, your domains be authentic, your algorithms be transparent, and your love letters be either original or properly licensed.
See you in the next legal love story.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.